Good morning, everyone. I hope you can all hear me. I think everybody who was waiting has now joined this webinar, and welcome to this, which is the first in a series of webinars from Garden Court Crime Team, looking at the position of children in our criminal justice system, with a particular emphasis on the challenges posed by COVID-19 and the situations we find ourselves in. I have some instructions initially, and then I'm going to hand over to our speakers. As you've joined us, you'll find that you've been put on mute by Amy, who's running the seminar for us. You shouldn't be able to unmute yourselves. Please don't try and unmute yourselves, because we're having to manage a lot of people in the webinar and ensure that everybody can hear the person they're supposed to hear. If you have questions, please post your questions in the chat window, and I will manage those at the end of the speakers and put your questions to both Joe and Kate. The slides which you're going to be shown will be available and sent to you at the end of the webinar. Please be aware that the webinar is being recorded, which means that the audio and video of anyone who's speaking is being recorded, and this recording may be shared. There's no other audio, video or personal data will be recorded or shared, and if you don't speak, then you won't be recorded. Today, we are very lucky to have the expertise of Kate Aubrey-Johnson and Joe Cecil, who are going to speak to us on the topic of the non-criminalisation of children during the COVID-19 lockdown. Kate helped establish and was director of the Youth Justice Legal Centre for 5 years, and Joe's criminal and public law practice have seen her instructed in every significant case at the appellate levels concerning juvenile justice in recent years. So we're very lucky to have their expertise. Kate is going to start us off discussing the principles behind why we should not criminalise children. And so I'm going to hand over to Kate now to start the presentation.
Thank you, Anya. So as Anya explained, this is a series of seminars where we'll be particularly looking at the position of children in the criminal justice system. So thank you very much for joining us today. This seminar is specifically looking at the non-criminalisation of children during the period of lockdown, and we want to discuss these issues because you will have seen in the press coverage of cases where children, and at times very young children, have been arrested, some under what appear to have been the COVID regulations and at other times for low-level offending. And we really wanted to equip practitioners with knowledge and expertise to try to address the risk that children who are restricted in their liberty because of the restrictions placed by lockdown, who will be under extreme pressure, often living in homes that are unsuitable without supportive parents or adults around them, may start to misbehave and act inappropriately, and there is a risk that they will be over-criminalised as a result. So welcome everybody. I'm going to talk initially about, not about what has happened since the coronavirus, but what the underlying principles have always been around the non-criminalisation of children, and why children should be treated differently to adults in the criminal justice system. And then Joe is going to talk about what has changed in terms of the new COVID-19 law and regulations and guidance, specifically around how that impacts the policing of children, touch on any potential public law challenges or civil actions that may arise as a result of conduct by the police that can be challenged. We have a few case studies if we have time to look at, and what might be on the horizon to happen next. I just also need to mention that you will be aware that the lockdown restrictions and regulations apply differently in England as they do to Wales, and for the purposes of this seminar we're just dealing with the position in England. We've heard lots about curves. I'm going to talk a little bit about curves in my talk, and I hope that this is not telling you what you already know, but I think it's always helpful to remind ourselves of what the underlying principles, why we say children should be treated differently when it comes to a criminal justice approach. So, as I'm sure you know, the principal aim of the youth justice system is to prevent offending. And what research tells us is that contact with the formal criminal justice system has a tainting effect. So in fact, the greater intervention of the formal criminal justice system, the more likely that children are going to remain in the criminal justice system. There is some excellent research. The most prominent perhaps is the Edinburgh study, which I've referenced here in the slides. But we know from a huge amount of research that system contact has a negative and labelling effect on children, increasing their likelihood of reoffending. And that is reiterated by the UN Convention on the Rights of the Child. Article 41 talks about how important it is that we avoid criminalising children unnecessarily and encourage and that we should encourage children to take responsibility for their actions, but the most important thing is to promote their reintegration into society. And of course, criminalising children, leaving them with a criminal record, can be a huge impediment to them in adult life, seeking employment and pursuing their, building on their strengths and pursuing their life aspirations. The other really important thing to remember is children, as compared to adults, may go through a period of offending, which may pass relatively quickly. So I promise you curves, here they are. These are two graphs taken from a very helpful document produced by the Centre for Justice Innovation. Oh, sorry, jumped ahead on that slide. It's a toolkit that you may find helpful because it contains quite a lot of the academic research behind what we know about diversion. So we know that informal diversion, diverting children away from the formal criminal justice system, is likely to have the greatest impact on preventing them or reducing the likelihood of them re-offending. And part of that is based on the fact that we know that children may re-offend during adolescence, and you will see from the first chart on the left hand side that there is a peak at about the age of 17, but children will naturally stop reoffending. And the second chart that looks at antisocial behaviour shows that in effect there are two cohorts of children who will be in the criminal justice system. And the vast majority of children will only offend during their adolescence and will naturally mature out of the behaviour and go on to live law-abiding lives. And therefore the response that the criminal justice system should take should be proportionate to that. The reason behind the offending curve, the fact that children offend in adolescence, is a lot to do with what we now know is the physiological development of children and young people. We know that that goes on actually into adulthood, so young adults are still maturing, and so physiologically children are wired, or adolescents in particular are wired, to not think through the consequences of their actions. They lack the maturity and the consequential decision making that adults acquire by the age of around 25. And I'm going to refer to a really brilliant anecdote that a colleague of mine, Brenda Campbell, QC in Chambers, has used, which is, if your partner or husband kicks a ball over the fence and smashes the neighbour's greenhouse, you're going to respond very differently to if the same thing happens, but it's your 14-year-old child. And really that's what we've got to remember about the criminal justice system and how we respond to childhood offending. And I've set out the summary of the reasons why children are less culpable than adults, as set out in the Sentencing Council's overarching principles. And a lot of it, the other aspect of child and adolescent brain development that we now know is children are also hardwired to be heavily influenced by their peers. And so there's a high likelihood that childhood behaviour is in response to children seeking affirmation and approval from their social group, and that they will then respond really well to any intervention or support work around who they're associating with, if they have the support through an early intervention or diversion programme. Alongside that underpinning principle that the purpose of the youth justice system is to prevent offending, and although it's counterintuitive that the best way to respond to a lot of child behaviour is to do as little as possible, or definitely in a criminal justice context, we've got to sit that alongside the duties that the police, youth offending teams, local authorities and courts have to have regard to a child's welfare. And that duty sits in section 11 of the Children Act in relation to the police, youth offending teams, public authorities, and when it comes to court hearings, we find that duty in section 44 of the Children and Young Persons Act 1933. So we've talked about why it doesn't achieve the purpose of the youth justice system to overly criminalise children, and therefore it's not in the public interest to generally speaking, to criminalise children, because it's not going to achieve what everybody wants, which is that they don't go on to offend again. And we also want to avoid what can often be a very traumatic and stigmatising experience. And we know that children who are detained in police cells, children who then go on to go through the criminal justice system, maybe have trials in Crown courts, will talk about the most traumatic aspects of their experience of the criminal justice system being detained in a police cell. So at all costs, we want to avoid children being detained at the police station. Where the principle of diverting children can be found in international guidance is from the UN Convention on the Rights of the Child. Again, we can look at both the best interest principle, but also the fact that the Article 40 sets out that wherever appropriate and desirable, states should have measures for dealing with children without resorting to judicial proceedings. That presumption is then set out in domestic law and guidance, or in terms of domestic law, the framework for out-of-court disposals is set out in LASPO 2012. In terms of guidance, I've set out some examples here. We've got the National Strategy for Policing Children and Young People from the National Police Chiefs Council. It's important that young people are not criminalised for behaviour which can be dealt with more appropriately by other means. The CPS legal guidance, which actually is under review, and we're awaiting updated guidance, but it talks about the presumption in favour of diverting children away from the formal criminal justice system. The Youth Justice Board's new strategy, well, last year it was published, talks about child first, offender second, and the importance that all youth justice services use preemptive prevention and diversion intervention programmes, and the out-of-court disposal guidance, which I'm sure you're all familiar with. There's an enormous amount of guidance on out-of-court disposals, but I find the most helpful starting point is the Youth Justice Board's case management guidance, which talks about offences of a gravity score of 3 or below, or a higher score where there are mitigating factors, should always be considered for diversion. So in every case, the youth offending team, if a case is referred to them, should be considering diversion. And really here we come into the area where it's a grey area, there is a lack of clarity. So although I talked about the LASPO, Legal Aid and Sentencing and Punishment of Offenders Act 2012, setting out the new framework for out-of-court disposals, that's when youth cautions and youth conditional cautions were created, and the opportunity to have community resolution and other informal diversion. That's all on a statutory footing that is mentioned. So in terms of statutory guidance, there is the option for informal out-of-court disposals, no further action, or community resolution. In terms of formal out-of-court disposals, we've got youth cautions and youth conditional cautions. I wanted to just mention here so that I didn't forget, of course, diversion is open even if children have already offended before. So it's not the case that you've only got one bite of the cherry. If a child has committed offences in the past, they still should be considered for diversion. And the other thing that I wanted to mention here is around language and definition, is that I was looking for some clarity on this. Out of court disposals and diversion are used variably. Some organisations refer to diversion as point of arrest diversion, and they're meaning that a child is never arrested. And of course, the child doesn't need to be arrested for them to receive a community resolution or for no further action to be taken. But other organisations also talk about out of court disposals as referring to those informal diversions that do not involve a child being arrested or coming into contact with a police station, for example. But generally speaking, when you talk about youth offending teams and you talk about any guidance that's available, out of court disposals are used as a more broad umbrella term to include both informal out of court disposals and formal out of court disposals. And the lack of clarity in this area does lead to some confusion, and I think police officers often don't appreciate that there are options to divert children at this early stage and aren't aware of the avenues that can be pursued. Joe will mention again later, but we are awaiting some guidance on out of court disposals from the National Police Chiefs Council and the CPS during the COVID lockdown that would apply as interim guidance during the COVID lockdown. So we've talked about diversion and informal out of court disposals. There actually are quite a range of options to the police. So in terms of no further action, that could mean that the police record the offences not in the public interest, which can either be Crying Out Code 9 or 10. Some of you, I hope all of you, will be aware of Outcome 21, which was created specifically in relation to offences described as sexting or youth-produced sexual imagery. And this was so that the police who were required to record offences of a sexual nature because of the Home Office counting rules, were able to record it but not have to take any further action. We currently have Outcome 22, which is a deferred prosecution outcome code. There is a pilot going on in London and other parts of the country. Some parts of the country have voluntarily adopted the use of this outcome code. Then we hear about people talking about youth restorative diversion, youth restorative intervention, and in London in particular, triage. This is where children are given the option to be referred to the youth offending team, receive either intervention through face-to-face or at the current time, it might be FaceTime contact with the youth offending team officer, or it would be attending a course. And if they complete that satisfactorily, then the police end up taking no further action. In other parts of the country, there are panels that consider these cases and decide whether they're suitable for diversion or out of court disposals. And they may have, as in Surrey, for example, and Sussex, I believe it's a youth restorative diversion. So in terms of what diversion looks like, you need to find out what is happening in your local area. And regrettably, we know from research that there are about 18 yachts nationally that don't even have a diversion programme, but the vast majority will. And my understanding from speaking to yacht managers is that they are running as much of their service as they can, and it's being modified, obviously, to allow for avoiding unnecessary social contact, but and respecting social distancing, but they are continuing to do the great work that they've been doing. So they should be the option for the police to deal with this through their normal channels, and of course community resolution. One of the examples that you may have seen in the media were two boys, I believe it was over the bank holiday weekend, who went into a supermarket and started threatening staff. later on that day, a parent took one of the boys back to apologise and apologised on social media. That, in my opinion, could be dealt with by way of community resolution. The police may want some more formal restorative justice work done by the youth offending team, but that's exactly how the police should be responding to childhood antisocial behaviour at this time. Particularly because it must be seen in the context that these children are under immense stress and strain. Of course, the formal out-of-court disposals are also still available, youth cautions and youth conditional cautions. But my understanding is that some police officers and some police officers working in youth offending teams are reluctant to actually give a youth caution or youth conditional caution at this time, because it would require them to come into close contact with the child. So it may be that they're being suspended in certain areas at the time. That would encourage me to suggest to be making representations to say, well, deal with it more informally so that the child can have certainty and the matter can be concluded and it's not hanging over the child during this period of other uncertainty in other parts of their lives. So that brings me to the end of what the position was before the coronavirus and the understandable government response and social restrictions that have been put in place since. So I'm now going to hand over to Jo.
Thank you, Kate. Hopefully Jo is now going to appear with sound and pick up the talk.
Hopefully you can hear me now.
Jo, thank you.
Excellent, thank you. This brave new world that we're all encountering at the moment. Okay, so the second section of this talk, as has already been described by Anya, is really to go through both the statutory scheme and the regulations that have been promulgated by way of secondary legislation by Parliament. Hopefully it will give you a bit of a broad overview as to exactly where the powers come from and what powers actually exist. It's been somewhat confused in its implementation so far, and we're going to talk a little bit about that as well later. So the legislation, we have a new Coronavirus Act 2020 enacted this year, very recently, unsurprisingly. But what's perhaps more surprising is that the primary regulations do not derive from that act. They actually come under the auspices of a much older act, and that's the Public Health Act of 1984. There are some specific criminal offences that are contained within the Coronavirus Act. They tend to typically apply to those individuals who may be infected, in short, with COVID-19. But the regulations are perhaps the ones that we're going to encounter more frequently, and they are the ones that have been subject to the most controversy in terms of recent weeks. I've set out here on the PowerPoint itself, they've instituted a number of pieces of secondary and delegated legislation. The primary one, for the purpose of this discussion today, is the Health Protection Coronavirus Restrictions England Regulations 2020. We've just termed them the Coronavirus Regulations 2020. It's a bit of a mouthful. What is interesting about those is that, of course, the Coronavirus Act itself was racing through Parliament at roughly the same sort of time. And instead of annexing criminal offences into the Coronavirus Act, what the government rather chose to do was to enforce through regulations and delegated legislation in terms of the coronavirus regulations. They require review by the Secretary of State every 21 days. The last review was by the 16th of this month. There's been no parliamentary debate in relation to the restrictions that are contained within the regulations, which is quite surprising considering that when one looks back over time, these really are probably the most wide-ranging and most restrictive measures that have ever been imposed on a population in England, in Wales, even surpassing those in terms of wartime provisions under quite sort of historic law now. There are, as has already been pointed out by Kate, significant anomalies dependent upon which territory you're in, England, Wales, Scotland or Northern Ireland. That's a consequence essentially of the devolved governments instituting the regulations themselves. And so perhaps one quite stark example is that in England, you're allowed to leave your home for the purpose of exercise. In Wales, that is limited to once a day. No real reason as to why Wales would have a somewhat more restrictive regulation than England or anywhere else. But ultimately, that's the rationale behind it. It's simply that different devolved governments are exercising these regulatory powers. And so for today's purposes, we're obviously concentrating on what the position is in England. As I say, there are nuances depending on other parts of the country. In terms of the regulations themselves, as we go through, and perhaps as we've seen, certainly from recent press criticism and what's been covered and reported in the press, there is a significant conflict with what is actually contained within the statutory scheme and the regulations, and ministerial statements and official advice. And that caused a huge amount of problems in the initial policing of this epidemic, because the police initially were effectively trying to enforce what ministers were saying applied, which was not actually the law or the legal position. And we've seen some quite high profile examples of individuals being pulled before the courts, wrongfully convicted of offences that don't even exist, and so on and so forth, in what can only be described as something of a kangaroo process, with no adjournments for trials or anything of that nature. So as a consequence of that, and quite significant input from, in fairness, both sides of the profession and other individuals, the MPCC and the College of Policing pulled together to quickly put out a police briefing paper, I think very quickly realising that actually they were losing any public support, and what they really needed to focus on was policing by consensus. And albeit that I'm pretty critical of the police generally, in fairness to them, it's probably the first time they've actually had to deploy themselves in any meaningful sense in relation to a public health emergency. And what we saw instead was effectively policing in terms of a public disorder or something of that nature. So what I've set out here are the guidance and protocols. And we'll all remember these weeks, because I think we were receiving guidance and protocols about 3-4 times a day of varying quality, varying standards and varying consistency. But they are really quite useful in at least outlining how the police see their duties now under the actual regulations, and quite helpful to pull certainly policing on the streets and those individuals back into line to some degree. I would advise everybody to click through. We will obviously be disseminating these PowerPoints. Each of them has a hyperlink, so you can directly go to the relevant briefing or piece of guidance, or indeed the acts themselves. But they're quite useful, because the reality is that the regulations themselves are very broad. There's no real definitions in terms of, for example, what's a reasonable excuse, aside from a certain specified amount of them that they've given as examples. And also, in addition to that, what we now also have, as it's already been set out by Kate, we have the MPCC and the CPS's charging protocol in relation to the COVID-19 crisis. That deals with those cases that are of priority, and I'm going to go through those shortly. And then secondly, and perhaps most importantly, the actual CPS public interest guidance that they've released. And as Kate has already said, that will be supplemented in due course by an out-of-court disposal piece of guidance. So really looking at the public interest. And of course, the public interest at the present time is very different to that which we previously experienced in terms of the environment that we are all operating in. Very sorry, for some reason my calendar's popped up. In addition to that, the professions got together and frankly did something pretty impressive pretty quickly, and managed to get a police interview protocol set up. I appreciate that there are still major practical difficulties in certain parts of the country, and I think the Met Police in particular are not necessarily covering themselves in glory in relation to this. But that protocol is in place. That again deals with some of the issues that you will be dealing with in terms of actually representing individuals throughout this crisis. And then the only other aspect is in terms of guidance. There's an awful lot of governmental guidance out there. And of course, one has to remember this is not the law. It's simply a policy document, but there are some useful frequently answered questions. last updated at the end of March, but as I say, they are inconsistent in parts, and it's perhaps illustrative of the situation that we've all found ourselves in at the beginning of this, in terms of the guidance that they give and what they say is acceptable and what they say is not acceptable. Turning then to the sort of global picture, what we have already seen is that the UN have responded on that broad global level in relation to the position of children. So children have been identified as forming a special category and this crisis having a particular impact upon them. How far their recommendations go is yet to be seen. We've seen some movement in relation to children in prisons, but certainly not enough. And certainly it remains to be seen exactly what the approach by the CPS is going to be to both historic cases that are already in the pipeline and those that are now going to enter the pipeline during the COVID-19 period. In terms of the UN Committee on the Rights of the Child, they essentially recognise that children's vulnerability is further increased by these circumstances of the pandemic. They call upon member states to release children in all forms of detention where possible. Alternatively, for those children who cannot be released, to ensure they have the means to maintain regular contact with their families. Just pausing there briefly, in the most recent Justice Select Committee, you may have seen the Lord Chancellor stating that children in young offenders institutions, secure children's homes and the like, and places of detention, all have phones in their cells or in their rooms, able to contact their families, and that's plainly not the case. We all know that, and that's simply not the real position on the ground. But it may be something that's also been informed by these communications. Finally, also they call upon member states to prevent the arrest or detention of children for violating guidance and directives relating to COVID-19. And that's why this particular aspect has been included within these slides, because of course we have the regulatory scheme as set out by the coronavirus regulations. The Office of the High Commissioner for Human Rights has also issued a very similar statement, again calling on a moratorium for those children being arrested and entering into detention, and also calling upon member states to release children from detention who can be so safely released. Of course, we're not really seeing anything like that at the present time. So turning now, if I may, briefly to the Coronavirus Act. Not going to spend a huge amount of time on this because ultimately they relate to infected persons and are much less likely to be things to cause issues in terms of our professional commitments and children that we come into contact with. But it's clear within that act that the responsibility for children complying with the restriction requirements rests upon those individuals who are either parents or have parental responsibility for that child. And so within the Act, although public health officers can place requirements or restrictions on a child, there has to be the presence of a responsible adult, save for in the most exceptional of circumstances. And so there is a recognition within the statutory scheme and to a large extent or slightly within the coronavirus regulations themselves, that children are a distinct category. But moreover, that in terms of their responsibilities, that there is a responsible adult that ought really in all of the circumstances to be dealing with these issues, as opposed to the responsibility falling onto the children of the family. So moving through to the regulations, as I said, these really do set out some of the most wide-ranging and restrictive prohibitions that we've ever seen, certainly in my lifetime, and I imagine most people's lifetimes. Regulation 6 is the most wide-ranging, and that provides that no person other than someone who is homeless may leave their home without a reasonable excuse. So what is a reasonable excuse? Well, a reasonable excuse is obviously a concept that all criminal lawyers are familiar with. It crops up an awful lot within the statutory schemes for ever offending. But in terms of the regulations set out 13 different potential reasonable excuses. But it should be remembered that that is not an exhaustive list. and that anything can potentially constitute a reasonable excuse in the normal way that we would argue these sorts of cases. That's an important distinction, because certainly at the start of the policing of this, the police approach was very much limited to, do you slot within one of these 13 reasonable excuses? And moreover, what do these reasonable excuses amount to? And that's why I say within this slide that it's really important to note the distinction between the regulations and the guidance that's been promulgated and the ministerial statements that we're all hearing, either at 4 o'clock, 5 o'clock, by whichever junior minister is being rolled out on a daily basis. And we saw a significant amount of policing failures arise. So I've set out within here, and I propose to go very quickly through them, the various reasonable excuses. You'll be familiar with, as I say, a large number of them, because we're being told daily what we can and cannot do. But certainly the most obvious is the leaving of your home to obtain basic necessities, food and medical supplies, supplies for the upkeep of the home and things like that. That in itself, with Easter, has caused its own issues. Is an Easter egg an essential supply? Does anyone really care, frankly? But those types of aspects. But it shows how nebulous the regulatory definitions actually are. The second one is to take exercise, which you can do either alone or with other members of your household. Again, there have been examples of families going out to play football in the park and being approached by police, being told to disperse. In actual fact, looking at this under the actual reasonable excuse parameters, one would expect that to be a perfectly lawful activity to undertake. To seek medical assistance for obvious reasons, provide care or assistance to a vulnerable person, or to provide emergency assistance. And certainly there have been examples of individuals being stopped and asked to confirm in some way, shape or form that they are providing care or assistance to that vulnerable person. And certainly from my personal perspective, I've had to sit down, draft out a note for a grandmother's carer so that she can leave her home address to go to the grandmother's address. To donate blood, that's still happening at the moment, surprisingly. To travel for the purposes of work, or to provide voluntary or charitable services where it's not reasonable for that person to work or provide those services from their home. Again, there was a lot of confusion over this initially, and whether or not it was simply key workers that could go to their place of work, or whether it was a much broader category. Lots of confusion there. Finally clarified with, effectively, if you have to go into work, you have to go into work, and if you can work from home, then you ought to be working from home. Again, not huge amount of clarity there. The next one is somewhat more depressing. To attend a funeral of a member of the person's household. You're effectively somebody in your household, a close family member of yours, or if there is nobody within those categories attending another person's funeral, then you can attend a friend's funeral. To fulfill a legal obligation, including attending court or satisfying bail conditions, participating in legal proceedings. So it's not a reasonable excuse not to necessarily attend court. Of course, what one has to set against that is the Public Health England advice, and consider the position of individuals in any event who may well fall into one of the vulnerable or shielding categories. And of course, one would not expect that to conflict with this under these provisions when it comes to them attending court, and one would hope that a court would not rely upon this provision in that way. Then to access critical public services, so childcare, education, if you, for example, you are a key worker, which we are all told we are, critical workers, we're attending court, so that your child can go to nursery or to school or anything like that. But also to access social services, DWP, victims of crime services, those types of things. The next one, again, caused some consternation in relation to children who have parents who are separated or moved between one or more households. And that's what this exception is effectively designed to deal with. There are some limitations, however, to it, because if one looks at it, it says to continue existing arrangements for access to. And of course, that really relies upon the fact that somebody has in place a very clear, defined pattern of contact or plan of contact of that nature, and so isn't particularly helpful in that regard, albeit one would hope that no other enforcement would take place in relation to other aspects of access. I'm really sorry, because that's my phone ringing. And there's nothing I can do about that. It's because it's the landline and there are several phones. So I apologise, but at least we've not yet had a small child appear, or a cat, which is also a possibility. So then moving through, there's an exception providing for priests and ministers of religion and so on and so forth to go to their places of worship. You can still move house where it's reasonably necessary, and you can also leave, and this is perhaps a slightly more applicable one, to avoid injury, illness, or escape a risk of harm. And we know from our own practices and from our experience that a lot of children are not necessarily in a safe place at home. Or there may well need to be some sort of cooling off period or something of that nature. A large amount of people are obviously having to live together in very constrained circumstances, not necessarily having any access to outdoor space or anything of that nature. And we are already seeing the rise of domestic violence incidents, entirely predictable and entirely depressing. What we then have within the regulations, if we move through them, is Regulation 7. Again, if you read Regulation 6 and Regulation 7 together, they throw up their own internal inconsistencies. They're not always reconcilable. But in short, it's the regulation that prohibits any form of public gathering, so social gatherings in public. And again, this is one which will probably impact upon children, because we know that children tend to hang out together and want to see their friends and all of those types of things. It applies to any gathering of 2 people or more. There are again exceptions unless they're from the same household. So for example, families, where it's essential for work purposes, attending a funeral, and again, then it goes back to facilitating house moves, providing care and the like. But again, what you also have to question is, what exactly does a gathering mean in these circumstances? There's no real guidance in relation to that. Can you all, for example, go out and clap or do all of those types of things and be two meters or so apart and enforcing in terms of social distancing? And we've certainly seen that in relation to, Westminster Bridge and the issues that flowed from there in relation to the police. So what exactly I'll start again. How do we enforce the regulations and what police powers are conferred? So the regulations themselves do not provide for a power of arrest. What they do is they provide the police with quite broad-ranging powers nonetheless to enforce those provisions. So turning back to looking at an individual being outside of their home without reasonable excuse, police have a number of options. They can direct that person to return to the place that they're living, so something akin to a dispersal direction that we often see, and we'll see that again when we look at the gatherings below. They can then also remove that person back to their home address, and in those circumstances they may also use reasonable force. So the application of that is yet to really be seen, but what we have been seeing are arrests not under these regulations or indeed under the statutory provisions by the police, albeit that one hopes that the guidance that has now come out has provided some level of education to policing moving forwards. Similar powers apply where you've got a gathering of more than 2 people effectively. Again, got the dispersal direction power, then actually the direction to return home, and then again to remove that person to where they're living. They're very broad. They entitle an officer to take action as they deem necessary. One would hope that necessity is quite a high test, but I would suspect that it will be construed very broadly. There is no real objective element to it, unfortunately. And so what you're really looking at are the subjective views of police and policing powers. So turning then to the child-specific regulations, again, as I said earlier, the regulations themselves recognise that children are different and that children should really, or ought to really, be under the care and protection of an appropriate adult that responsible adult. And so the regulations themselves also provide for directions and actions to be taken in relation to those responsible adults if they are with the child at the relevant time. And so they can direct that adult to take the child to the place where they are living, and that individual must, insofar as they are able to, so insofar as reasonably practicable, ensure that child complies with that direction or instruction. What's interesting is that there is a safeguarding aspect that is imported within the regulations themselves. And so where a relevant person has reasonable grounds to believe a child is repeatedly failing to comply, they may direct any individual to secure, as far as reasonably practicable, that the child complies with that restriction. So that's the type of thing that we'd expect to see if police were coming across the same child again and again and again. But of course, what one should be questioning at that point is, why is that child out? Why is that child not under the care of that responsible adult? And what is actually going on here? And are there wider safeguarding issues? Just a note on the construction, wherever you see the words relevant person, that in England applies to an officer or a PCSO. It's broader than in other parts of the country, or alternatively, an individual is designated by the Secretary of State. We're not aware at the moment of any other individuals, but I'm sure there will be. And so turning then to the tests and in terms of the powers, as you can see here, what it really amounts to is quite a broad, nebulous and subjective test. There's no requirement for reasonable belief or any level of objectivity. What they say is simply that if the relevant person considers it to be a necessary and proportionate means of ensuring compliance with the requirement. So it caveats the powers to some degree, but then also takes it away on the other hand by making it into essentially a subjective test in terms of what is happening within that person's thinking process at the time. So how do offences arise? Those are set out in Regulation 9. I should add that there are other prohibitions within the regulations. Those other prohibitions relate primarily to businesses and carrying on in terms of business premises and the like. So we've not concentrated on those at all because they don't seem to be particularly relevant for today. But in terms of Regulation 9, it's much more broad ranging, and it applies to an awful lot of those aspects as well as the ones that we've discussed. So it is an offence to contravene any requirement in Regulation 8 without reasonable excuse. And as I say, we're used to the reasonable excuse test. I'm not going to dwell on that for any significant period. But a person who therefore without reasonable excuse contravenes a direction or fails to comply with a reasonable instruction or prohibition notice will commit an offence. What's important is that those offences are only punishable on summary conviction by a fine. They're non-recordable offences. And the reality is that the guidance is very clear that really a very different approach should be taken. And I'm going to move to that in a moment. But in short, that there is the availability of fixed penalty notices in Regulation 10. Of course, fixed penalty notices, as we'll see in the next slide, they simply cannot and do not apply to children in these circumstances, but they're important to know about because they can apply to the responsible adult, the parent or person in charge. They start off at £30. Of course, you can breach more than one regulatory prohibition at the same time, so it's not necessarily limited to a single £30 FPN. The second one jumps to 120, and then from there onwards, you double them. And you can see here up to a maximum of just under £1,000. Of import, some areas do not yet have in place provisions for administering fixed penalty notices. Most do, but that was one of the major problems at the outset of this, was that individuals were being arrested effectively and brought to court because they simply did not have the administrative processes in place to administer these types of notices. So moving then to the power to arrest, well, as I've already set out, there is no power to arrest within the regulations themselves. You have to effectively fall back onto the provisions within section 24 of PACE and so on. The regulations place clear responsibility for children complying with the restriction requirements on individuals who have responsibility for that child. But notwithstanding that, children can still be directed and removed to their residential addresses, and that includes the use of force. There is no power, and again, this is one of the misconceptions that grew up around these regulations when they were first implemented. There is no power to stop an account or anything of that nature. And I suspect that the reality is that what we will see is that although children may be breaching regulations, they will ultimately end up being arrested for other offences, resisting and so on and so forth. So arresting children then during the pandemic. So as we set out here, is it really going to be proportionate, reasonable or lawful? In terms of the actual coronavirus regulations themselves, there is a strong policy statement now from the NPCC that this is all about policing by consent. So it's all about engaging, explaining, encouraging, and then enforcing at the very sort of last resort. But of course, as we know, children are not necessarily the most compliant or pliable when it comes to their interactions with the police, not least because of the way that the police actually deal with them. But given the profile of children who may well be out during this period, then really, and it's set out here, then they ought to be engaging with those children and ascertaining why they're not adhering to the various prohibitions, why they're out, why are they not socially distancing and so on. And the reality is that most of the time it will simply be because they're children. And of course, we've all been told that children and young people are really at very little risk, if any, of the coronavirus. So inconsistent messaging. The NPC and the College of Policing briefing paper is quite helpful actually on these aspects, because they really do emphasise the importance of safeguarding and trying to understand the fact that although everybody is told to be at home right now, it may not be safe for everybody to be at home. So whatever issues are at play effectively. So is there domestic violence? Is there abuse going on in relation to that child? Neglect? Are there mental health issues taking place? So is it safe? If it's not, then of course one would expect safeguarding referrals to be made. And I've set those out towards the end of the slides in terms of the various powers and duties on the local authority and other agencies. Kate's already been through this to some degree, but of course we all know the profile of those children that we often come into contact with who are offending, and they often share similar characteristics. Many have those adverse childhood experiences, and that's going to feed into their experiences of the COVID-19 lockdown. Many may well have found solace at school, those that still attend school. That's not necessarily something that's going to be available to them at the present time unless efforts are made to actually put them back into school, depending on whether they fall into one of the key groups. And even if they have an ECHP, the advice still in the guidance is, or a social worker, the guidance is still that if they can stay at home, they ought to be at home as opposed to going into school. And so that all of that just creates an even more complex picture in terms of what are these children going to be doing during their days. They're often, and as we know, children in the criminal justice system often have complex and quite multifaceted needs. There's a prevalence of learning disabilities and those types of issues, and a prevalence of exploitation. And we know that there is overrepresentation of BAME children and looked after children within the system. And so that's why I say and flag it up at the outset that ultimately policing ought to be asking why are these children here and what can we be doing to actually create a safe space for them. They do have welfare duties in terms of the welfare assessment, and policing ought to make a proper assessment of those circumstances. Are their living arrangements suitable? Is there interaction with other agencies? Ought they be contacting other agencies at this time? Some children may well have a point of contact who is their social worker or their youth offending team, who may not simply be there right now. And certainly in terms of social distancing and the like, may not be able to have any appointments or have that level of support that they normally have. And then finally, are there alternative arrangements in terms of where that child could potentially go if there are problems? So moving then to those children who are committing offences during this period. It's really important to take a look at the CPS charging protocol and the police interview protocol as well, And then finally, the public interest protocol, just to get a sense of the types of representations that can be made when you're dealing with children coming into the criminal justice system now. So certainly what one anticipates is some relatively low level offending. Of course, much more serious offending is going to be treated in the way that it was previously. And we see that from the charging protocol that's set out here. There are 3 categories of case. This is obviously this is by the time it comes to the CPS. By that point, it ought to have been through the filter as set out above, as with arrest being a last resort, not least because of the real practical challenges at the present time and resource implications within the police stations themselves. Police stations themselves obviously not being a place of safety, and certainly the risks of coronavirus spreading and so on and so forth in terms of the health aspects need to be taken into account. And the police interview protocol, the joint one, is actually very useful in that regard. And when it comes to the charging protocol from the CPS, again, that's quite detailed. It does set out a small part in relation to youth court cases, but the public interest one is perhaps more helpful. They do need to be read together. So you have 3 categories of case, of course. Category A cases are always going to be taken very seriously indeed. So those are the homicide cases, serious robberies, serious assaults, serious public disorder. What's interesting there, of course, is that within the category A situation, one has coronavirus regulations and related offending. And certainly one can see from some of the case studies that we may be discussing later, spitting or coughing at health workers or whoever it may be in supermarkets or simply out on the street is going to be taken very seriously when one looks at the public pronouncements by the CPS in relation to what they're going to do about those offences. But of course, set against that, it's also quite childlike behaviour from children. Or when it comes to adults, we often see it where individuals have mental health issues. And so it's not quite as straightforward as one would have thought. And I think those cases are going to need quite careful and quite sensitive handling moving forwards. The next category of case are those high priority cases. These are custody cases primarily within the courts themselves. What's interesting there is that they include serious offences that include youth court cases. So it may be that you've got a young person who is a defendant in a robbery or something of that nature. The aim after triaging out category A cases, so those overnight remands and things like that, is to progress these youth court cases as quickly as possible. In terms of practical considerations, many of you may know better than I, but certainly the information that we are receiving on a daily basis is that the Magistrates Court and the Youth Court are very severely under-resourced, both in terms of staffing, but also in terms of judicial decision makers. And not least because of the profile of a large number of lay benches who are typically older and probably fall into those vulnerable groups who are either at home for the 12 weeks or shielding. And so what's happening, as we understand it, are that district judges are being utilised, but that inevitably is going to mean that there are nonetheless quite significant delays, and certainly when it comes to trials. And I'm aware of the various remote pilots and so on that are taking place in relation to those. And certainly we have our own concerns in relation to that, and we'll discuss those a little bit later. And then finally, the third category are those other cases, which are basically the least important as far as the CPS are concerned. Those cases where you can be released under investigation or there is no arrest required. And so a lot of the charging protocol policy is driven by practical considerations with regard to resources and allocation of scarce resourcing during this pandemic. The public interest test, I've set out the relevant parts on the following page, is important because it directly refers to the guidance for young people, but it also deals with, to some extent, out of court disposals. And so the public interest has essentially changed in terms of that second limb of the CPS charging decision making. So whether an out-of-court disposal may be an appropriate response to the offender or seriousness and consequences, The second one, effectively to some degree plea bargaining. So whether a guilty plea to some but not all charges or to a less serious offence will enable the court to pass a sentence that matches the seriousness of the offending. And we are seeing more and more judges being urged from quite high levels to be pragmatic, is probably the neutral way of putting it, in their approaches to sentencing. And so there is a big emphasis at the present time on compromise, and incentivized sentencing is probably how I would describe it. So for those sorts of cases, there is a potential opportunity for proper negotiations and proper discussions. But of course, one also has to always bear in mind that you don't end up putting a level of pressure onto a defendant in these circumstances. Other factors are the length of time that they've spent on remand in custody, any other likely period of time remaining prior to trial. And then, as I say, the youth offence is one in particular. And so the key part about that is that there is this requirement to deal with cases expeditiously, to avoid delay. And the reality is that at the present time, that's just simply not going to be possible. And so I think in that sense, one can leverage those aspects when it comes to making representations. And there are very few cases in which it would not be appropriate to be making representations again now. The CPS have been urged to review all cases that they have in terms of their own internal caseload to see what cases are potentially capable of resolution. That applies not only to youth court and magistrates court matters, but also to serious matters in the Crown Court. So there is a very concerted effort to try to deal with some of these aspects, not least because of the backlog that will then take place moving forwards. The ethics and so on and so forth of that, I make no comment on at all, she says. So then we have the COVID-related offences that I've already spoken about very briefly, the spitting, the coughing, high priority cases. On the face of it, high public interest. But again, still really important to make those representations. Is it just childish behaviour? And moreover, why are they out? Those sorts of questions. At the same time as dealing with these cases, because why are they out is a really important question. The possibility of referrals to the local authority and individuals or other agencies is actually really critical at this time. So you've got the provisions under the Children Act, either the Section 47 child protection referrals or the Section 17 child in need assessments. Again, if there is a child that simply is homeless, and I suspect the incidences of that taking place are quite likely moving forwards, also ask for the Section 20 assessment in relation to finding some form of accommodation for those children. I'm just aware of the time. It's a bit of a whistle-stop tour, all of this. But moving then through very briefly, we've just set out a few ideas on the next slide in relation to potential challenges or claims. There is plainly a challenge or a potential challenge in public law terms to the lawfulness of some of the restrictions within the regulations, not least because it's not actually parasitic in terms of the statutory legislation. And has come instead through, as I say, the devolved aspects of secondary legislation. There are significant aspects that engage provisions and principles in relation to deprivation of liberty, both in terms of the common law, but also in terms of Article 5 and the Human Rights Act. And one has to question whether or not there really is the statutory authorisation that is necessary for such wide-reaching prohibitions. Set against that, of course, one has the public interest and the fact that we are in relatively extraordinary times. There are many challenges that may arise out of policing. As I said earlier, this is a public health emergency and not a public disorder situation, calls for a different type of policing. And when one looks to the guidance, there is a hugely fertile aspect, potentially, of challenge in relation to necessity for arrests and detention, misuse and misunderstanding of powers. And we'll be more than happy to discuss those in due course. But what we thought might be a little bit more interactive was to start looking and invite some discussion or questions and answers around some case studies, some things that have already arisen in the press, because We all know how tiring it is, I'm sure, from our many Zoom conferences, in terms of watching things on screens. So perhaps at this point, I'll hand over to Anya.
Thank you very much, Jo, and thank you to Kate. Before we go into the case studies, can I just mention, I think Kate's going to be able to launch a poll, which we'd ask you all to take part in. There are 2 questions on the poll. The first is, how many of you have had experience of children arrested since the implementation of lockdown? And the second question, how many of those were arrested for COVID-related offences? I think there's still approaching 100. There's 90 people present. I think we started with nearly 100. 90 of you still with us. But I'm going to hand over to Kate immediately in the hope that she can launch the poll. And as we deal with the case study and questions, if you could perhaps respond to that poll.
Has it appeared? I've created it.
No.
Right.
Okay, we will come back, hopefully. Oh.
Yeah, it's supposed to give me the option to launch it, but I'm not able to do that. So maybe Amy, I can just ask you to look at whether you're able to launch the poll. I'm getting messages saying that people can see it. So I think what it will require people to do is to go to either the bottom of their screen or the top of their screen, where they'll have a list of options which will include chat and polling. And if you click on polling, I think that you'll be able to access that. The purpose of doing the poll is just to try and get a gauge on how many children are being arrested and how many of them are being arrested for COVID-related offences, because the police briefing has really given a strong message that arrest should be the last resort, and certainly that in the context of this public health emergency, children shouldn't be, or anybody shouldn't be being arrested for minor or low-level offences. There definitely was some confusion at the outset, but that hopefully that has settled down. I'm afraid that I'm not technically savvy enough to have been able to. Okay, if you give me a second, I'll go back to, I don't know if I can amend the poll, because people are being asked to answer the second question, even if they've answered no to the first.
Okay, shall we move on? What I suggest we do is, Kate, if you have a look at the poll and see if we can sort out that glitch. And if I can just ask a couple of the questions that have been posed as we've gone through, and then Jo, if we go to the case studies, we've got about, it's just gone 22, we've got just short of 20 minutes until I think we lose the facility to carry on doing this. I'm going to skip the first question for the moment, because that one is to Kate, who's dealing with the poll. The next question is really a comment, but something you may be able to comment on, Jo, in that Stephen Jones said that the West Midlands police seem to be universally ignoring the police interviewing protocol. And do you have any suggestions about what we do about the fact that police forces aren't actually complying with the protocols?
Just unmute myself. Yes. So what's happening is every evening there is a 5 p.m. briefing meeting that is taking place between leaders of the professions and the MPCC and various other organisations. If you can report it back, I know that the LCCSA Law Society and the CSLA have an app set up, as I understand it. I think it's been facilitated by Tuckers to report poor practice, both in police stations and in the magistrates' court. If you feed it back into that can get raised then at the 5 p.m. meetings. And what tends to happen then is it gets cascaded back down, and it does seem to have quite a positive impact in terms of changing practice. So that would be my advice. I didn't realise West Midlands were like that. I knew we've certainly had feedback in relation to parts of the Metropolitan Police and some other parts of the country, but I've not heard anything about, I don't think, about West Midlands at the present time. But I can feed that back as well this evening.
I think the other thing Jude Lantin is suggesting is to submit a complaint to the Law Society as well in relation to coming across those difficulties. Next question, I'm going to, in two parts, I'm going to set them both out, and I think probably more for you, Jo. They come from Jude Lanchin.
Okay.
Please can you clarify how you define reasonable excuse in Regulation 9? And second part of it, given there is no power to stop and account, what do you consider the legal basis, if any, for police stopping people to account for their movements?
So I think in terms of defining reasonable excuse, we don't really have any examples yet to go from in terms of any case law or anything like that. So I think it's just simply a case of us applying our own existing knowledge from other aspects of the law, and then comparing and contrasting that with the driving aims of the regulations themselves. What are they there to, what is the aim, and what is the reasonable excuse? I mean, some people have posited various different forms of, is this a reasonable excuse or is that? So going out to buy, I don't know, I think somebody suggested going out, we certainly had the Easter egg issue, going out to buy an Easter egg, those types of aspects will probably nonetheless, going out to buy food. But going out to buy paint for your house in circumstances where the maintenance and upkeep of that house is not essential or vital is really vague as to whether or not that's acceptable or not. You'd hope that the police would use their common sense in that regard, but who knows, is the reality. So I'll be frank, I can't define it, Jude. I'm afraid. We've both Kate and I have discussed it, and I've discussed it with other colleagues in chambers. And all you'd hope for is, as I say, a pragmatic approach to this. But I suspect we're going to be running certain cases going forwards if need be.
So if I can just add that Laura O'Brien has just helpfully posted on the chat that the document that's also referred to in the slideshow, which is the College of Policing and National Police Chiefs Council joint guidance on what constitutes a reasonable excuse. Now, of course, that is just guidance. It's just yet another document that can lend weight or not to the arguments that you might raise. I believe that might cover the Easter egg example, because it does I think mention about luxury goods, which I think Easter eggs might count as. So that would be a reasonable excuse.
I've just seen that Jude and Caroline have updated actually Jude's question. I think I've got confused. I think we got a bit confused as to
the way that I posed it.
Yeah, I mean, if you're out for a reasonable reason, just to read it in, but then get told to go home by the police, would it be reasonable to refuse to do so? Well, the difficulty is under the regulations, if you are given that direction, then the regulation provides that you must follow that direction. So I think that would move the position on, unfortunately. Not to say it's not potentially arguable, but I think it would be quite difficult.
Also, just to pick up on, it's also been mentioned in the chat that there is a form for registering or reporting those police stations that are not complying with the protocol in terms of the protocol for social distancing and police interviews, if I'm right.
That's the one that we were talking about. I was discussing earlier. So that is it. It's under the case ratio link.
Yes.
And it applies, as I say, not just to police stations, but also to courts. And as I understand it, there's been a lot of feedback in relation to police stations generally, but there is not so much feedback coming in relation to courts. And of course, albeit the Crown courts have more or less stopped, the magistrates' courts are really causing quite some level of concern at the present time. So the more feedback, the better, I think.
Right, can I just mention now that the poll it's on the chat, but in case people aren't all following the chat, the poll has been amended and you should now be able to respond to the poll. And then I'm going to move on to a different question, one which was posed initially early on in the webinar, which is in terms of the informal out-of-course disposal options. Which of them require admissions in interview in order to obtain them? Like going back to the beginning of Kate's talk.
Yes, I'll tell you what, I'll just share my screen and bring up the slide that dealt with that. think I can do that. So I mentioned the different, I'm so sorry, I mentioned the different out-of-court disposals that are available. One of the issues around out-of-court disposals, as you'll all be aware, is that many of them don't become available unless the suspect has made an admission. In relation to community resolution, I don't believe there is a requirement that there has to have been an admission. That would depend on the discretion of the police officer and how they were going to deal with that matter. In relation to outcome 21, there is no requirement for there to have been admission. In fact, many people are unaware that that has even been recorded by the police. If, for example, the school has reported an incident of sexting within the school, the police officer linked to that school may record it and the child might be unaware. Deferred prosecution by its nature, because it's supposed to be addressing out of the Lamy report the fact that there seems to be a disparity in terms of both the opportunity for people to be offered diversion or out of court disposals, and also whether people make admissions, and therefore that precluding them getting the option of an out of court disposal. So in that instance, there doesn't need to be an admission. I believe all of the schemes in relation to, or most of the schemes in relation to triaging or youth restorative diversion or intervention do require an admission, but the guidance that has been issued throughout and what the Centre for Justice Innovation advises when they train youth offending teams is that the option for an out of court disposal should not rely entirely on an admission. I hope that answers your question.
Thank you, Kate. Can I just come back to the second part of the question that Joe Lanchin asked, which is about what power the police have to stop people and get them to account for their movements. Where does that power come from?
So there is no power expressly within the regulations, and their own guidance says that effectively it's not a stop and account power. Equally, the reality is, and it's one of those anomalies that's within the regulations, if you have to have a reasonable excuse to be out, and it depends whether the police are approaching this from a presumption that there is no reasonable excuse to be out. One wouldn't expect the police to necessarily be stopping individuals who are on their own or in family groups, but as I've said, that has happened, particularly with family groups, and is happening, or was happening at some earlier stages. There is no requirement on an individual to provide an account. It's really as simple as that. Of course, where that goes from there in relation to other powers and other potential powers that could be utilised by the police is a different matter. And I've noted that one of the issues that's perhaps come up in relation to that, which is to some extent related, is the stopping and searching cars. And again, there is no power of entry or power to stop vehicles under the coronavirus regulations themselves.
Thanks. Can I just partly link to that? One person wanted to clarify, I think in fact you dealt with this a little later in your seminar. The COVID regulations are not arrestable offences. That's right, isn't it?
Yeah, that's certainly the coronavirus regulations themselves give no power of arrest. So the only provision to arrest would have to be found elsewhere, essentially, in other aspects of legislation. But there's certainly within the coronavirus regulations, it's something that's actually very vague, I think, in a similar way to whether or not what powers they have in relation to children are under the regulations, because there is no, when you read the regulations, there is no defined power within those, or indeed within the statutory scheme that they are parasitic on. So the power to arrest must come effectively from other aspects of the criminal law.
So for public,
that would be my view. That would be my view. But I've not been able to find a definitive answer anywhere, because certainly when they were first announced, it was very much there is a power to arrest here. The police now have been given new powers. They can fine people, they can arrest people, they can do all these different things.
Okay, thank you.
Sorry to be more clear.
That's fine. Can I just check on that? When you say the power comes elsewhere in police powers, you mean that there's a power to arrest for other public order offences rather than there's a specific arrest?
Yeah, all other aspects, and it's as I've already said, under Section 24 of PACE, for example, or if you were seen to be obstructing a police constable in the execution of their duty or something of that nature. So you'd have potential powers that could arise in that respect.
Can I just come in, Anya?
Of course.
Just to say that I think you're right, Joe, in terms of, and there's a comment being made on the chat around Section 24 of PACE. I'm fairly sure that the police briefing talks about that being the power under which any arrest might take place. The police briefing, which we've set out in the slides on the coronavirus regulations, also talks about stopping and searching cars.
Okay, thank you. Do you want, I think we've got 5 minutes left. Do you want to take us through the first case study that you put there?
Oh, I'm now on the slides, Joe, so shall I take us to it?
Yeah.
So this is, oh, sorry. This is about a boy aged 13 who was arrested after refusing to give his name to the police and taken into custody. Shall I hand over to you, Joe?
Yep, give me 1 second. Just hold on. Okay. Yeah, so this I'm coming off mute. So this is an example at the very outset, effectively, of the lockdown. And he was taken into custody. We've seen a more high-profile example involving a woman at a rail station who was taken into custody, was arrested, remanded overnight, effectively brought before the court, tried, as I understand it, later that day with no representation, and so on and so forth. The difficulty here is we simply do not know enough about it to comment on it in any meaningful sense. It seems to me that refusing to give your name to the police is not an arrestable offence under the coronavirus regulations. Certainly ought not to have been taken into custody, because there's simply no necessity for doing that, unless there is a safeguarding issue in terms of transporting him to a safer place, albeit there are question marks over custody in that sense. But what I think is interesting here is that his mother is then reprimanded. So at some point they've discovered his identity to understand who his mother is. And so it's very difficult to know exactly what happened in this particular case, but it's an example of the very, very poor policing that was certainly taking place at the outset of this pandemic, and certainly it appears, and I'm afraid I simply don't know what the situation is now on the ground in relation to the policing now, but certainly from the Metropolitan Police angle, I know that there have been again poor examples of that.
Right, thanks, Joe. What I think is, I think this is a conversation that could go on for a long time, but it's coming up to lunchtime and people are starting to leave. So I think it's probably a good idea that we bring this to an end now, with thanks to everybody who has dialed in, with thanks to you, Joe, and to Kate for the information and taking us through the talks. Just to let everybody know that the plan is that we're running a series of seminars at this time on a Tuesday. Next week, we're looking at ending indefinite pre-trial detention of children, and we have Audrey, Cheryl Mogan and Mike Gould from the crime team, and a colleague in chamber, Naomi Wiseman, who I think is a family practitioner, presenting that seminar next Tuesday at the same time. So please join us then. Details of the seminars going forward are on our website and will be emailed around. As I've already said, the slides from this talk will be sent to everybody who has attended. Thank you very much to everybody, and take care, everybody. Keep safe.
Thank you.